Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. So today I'm actually studying legal writing and research, and there's a lot in there, so I don't even know where to start. But where I'm going to start with is something that I think every lawyer has to know. And those are, what are the four primary sources of law? So think about it for a second. What are the four primary sources of law? There's the constitutions, there is the statutory law, there is the case law, and there's the administrative law. So those are our four primary sources of law. Also, in United States, they have three branches of government. This is something they teach in every high school, so you probably know the answer to it. It is the executive, legislative, and the judicial. These three branches of governments, they all work together to make laws, and basically they work hand in hand, the balance of power. So checks and balances. And also there is the case law, which is the primary law, versus the secondary law, which is the model acts of law. And then the primary legal sources are resources that are the law itself. Okay, so for a second, I would like to pause. What are the primary sources? There's the Constitution, there are the codes, there are the opinions, or the regulations. These are the primary sources of law. The distinction between primary and secondary sources is important to researching and writing about the law. So you have to know the differences between a primary source and a secondary source. That is very important when you're researching and writing. And authority from primary sources is usually called a primary authority. And the secondary legal sources are anything that is not the law. Okay, so secondary sources are always persuasive and not used as a legal authority. And you must always be mindful of the difference between a primary and a secondary material. Okay, that is very important. Okay, so now that I've introduced this to you, the next thing I want to talk about is how do judges decide? So judges usually decide based on a stare decisis, which is a let the decision stand. So what do I mean by that? The decisions in the present case are based on a past precedent. Okay, so I think you kind of are beginning to understand what I'm talking about. So the judges decide the cases based on a decision made in a past case. Okay, so now the next thing I want to talk about is how are case laws developed? Okay, so as I just said, there's a precedent, which is a decision in a previous case that provides a rule of law that may apply in a current situation. And so I just described that. I'm gonna really lose my concentration if I don't tell you this now. So usually lawyers, they go to like the usual sources of law to do a research, which is the Westlaw, which is the LexisNexis or Bloomberg law. These are the type of things that they provide to law students in the first year of law school, and law students, they have access to this all throughout the law school. But once these law students, they become attorneys, they're going to have to pay out of their pockets to purchase this and do their research on that. But you know what, when you're trying to do your research, you really want to be cost effective and time effective, and maybe using these research tools is not always a good idea. So this is where my advice comes in. You know, like when I want to research the law myself, where I start with is usually I start like Googling, you know, like I Google the cause of action, the claim that I think that I have, such as, for example, let's say negligence or defamation. I start with the Google, I find some cases, I find some statutory law, or I'll go to the secondary sources. So Googling is actually secondary sources, you know, like other people's arguments, magazines, newspaper, pretty much like anything I can find, I'll look for it on the internet. So it's very important for you to familiarize yourself with the classic legal research finding tools. But also don't forget, you know, like I love to go to the library. Something that people forget to do is pick up a book. For example, you want to search negligence. Why don't you pick up a book, go to the table of contents, and see what cases are available there? And just start reading those cases and kind of like go through a mind exercise and go from there. And these are some things that are really important. I'm not going to go too much into it, but these are things that you're going to be introduced to in your legal writing class. And it's very important to pay attention to it. Like, I wasn't paying attention to it in my first year of law school. I'm very bad at citations, but this is something that I had to learn the hard way. So don't make that mistake. Pay attention to the citations, to the key numbers, to the head notes. Also pay attention to the popular name table, indices, table of contents, and annotated primary materials. Don't forget to pay attention to those. So, as I said before, the secondary sources provide connections between the materials and the context. So, what does this mean? This means legal research is the manner by which lawyers gather all required and persuasive materials necessary to advocate for their clients. So, how I see this is that lawyers are supposed to be like philosophers, okay? What does this mean? That means that they have to think way outside the box, look for answers all over the place, maybe discuss it, you know, bounce ideas around. So it's very important for lawyers to use all the required and persuasive materials necessary. So they shouldn't leave anything out, you know, they should be doing the research thoroughly. And something that is very important is the efficiency in legal research, okay? So you gotta be efficient. Like, as I told you before, you wanna be mindful of how much money you're gonna be spending and how much time you're gonna be spending doing this research and developing your work, because it's gonna be like a very long project and you got to be patient. Sometimes going through other people's problems, it just sounds so absurd. Like, in your mind you'll be like, seriously, you're fighting over slipping on a banana? Seriously, is this like our civilized society? But you know, the reality is that no, people get injured and you gotta be mindful, you gotta be sympathetic. So when you're reading the fact pattern, be sympathetic. You're trying to help these people, and it doesn't matter how absurd their problem is. Okay, so the best results are the results that take the least possible amount of time and at the lowest cost. So there's still a little bit more into this, but my video is kind of getting a little long, so I'm gonna pause here and I'm gonna make a part 2 of this video. Have fun studying.